Number 1. Chris Watts, the man behind the perfect family. There are crimes that stop a nation in its tracks. Cases that force ordinary people to confront the uncomfortable truth that the most dangerous place a person can sometimes be is inside their own home, surrounded by the very people who were supposed to love them most. And the story of Christopher Lee Watts is one such case. A story about the vast and devastating gap between public appearance and private reality, about the carefully constructed image of a happy, suburban family that concealed something deeply troubling beneath its surface, and about the irreversible consequences of choices made in the quiet darkness of an ordinary American home. Because this is also, and most importantly, the story of Shawn Watts, a woman of 34 years who devoted herself entirely to the people she loved, who shared her life openly and joyfully with thousands of followers on social media, who was weeks away from welcoming a third child into the world, and who deserved immeasurably better than what found her in the early hours of August 13, 2018, in the small city of Frederick, Colorado. Christopher Lee Watts was born on May 16, 1984, in Spring Lake, North Carolina, and those who knew him in his younger years described him as quiet and withdrawn. A young man who kept largely to himself, who did not seek attention, and who presented to the world an unremarkable and inoffensive exterior that gave no indication of the internal landscape he carried within him. And after completing his schooling, he worked various positions before eventually finding employment in the energy sector in Colorado, where he secured a role as an operator with Anadarko Petroleum at an annual salary of approximately $61,500. Which placed the family in a reasonably comfortable financial position on paper, though the reality of their finances was considerably more complicated than that figure suggested, because court records would later reveal that the Watts family had filed for bankruptcy in June of 2015, carrying nearly $70,000 in unsecured debt alongside a substantial mortgage, a financial pressure that would quietly accumulate beneath the cheerful surface of their social media presence for years. Shawn Razusek was born and raised in North Carolina in a close and loving family, and those who knew her described her as a driven, warm, and energetic woman who faced genuine adversity with remarkable resilience. Because Shawn had been diagnosed with lupus, a chronic autoimmune condition that affected her health significantly, and it was partly through this period of physical vulnerability and emotional difficulty that she first connected with Christopher Watts, who sent her a friend request on Facebook, and the two began a relationship that eventually led to marriage, with Shawn later telling friends and family that she had been drawn to his patience and steadiness during a time when she needed support, a description that would carry a particular and painful weight in the years that followed. The couple married and settled in Frederick, Colorado, in a 4-bedroom home in the Windham Hill neighborhood, and together they had 2 daughters, Bella, who was born in December of 2013, and Celeste, known to her family as Cece, who was born in July of 2015, and Shawn documented their family life extensively on social media, sharing videos of birthday parties and holiday celebrations and ordinary Tuesday evenings, building a following of thousands of people who watched the Watts family and saw in them something warm and aspirational, a young couple navigating parenthood and life together with apparent happiness and mutual affection. And Shawn also worked as a distributor for a nutritional products company called Louvel Thrive, a position that allowed her to work from home and that she promoted enthusiastically online, frequently crediting the company's products with helping her manage her lupus symptoms and maintain her energy as a mother of 2 young children. By the summer of 2018, Shawn was pregnant with the couple's 3rd child, a son they had planned to name Nico Lee, and she shared the pregnancy news publicly with the kind of genuine joy that had become characteristic of her social media presence, expressing excitement about expanding their family and posting updates about the pregnancy for her followers. And to the outside world, the Watts family appeared to be exactly what they presented themselves as, a loving couple, building a life together in suburban Colorado. But the reality behind that image was fracturing in ways that Shawn was only beginning to understand, and that those around her would not fully comprehend until it was far too late. What Shawn did not know, and what investigators would piece together in the days and weeks following the events of August 13th, was that Christopher Watts had for some months been conducting a romantic relationship with a coworker named Nicole Kessinger, a woman he had met at Anadarko Petroleum, and that in the weeks leading up to the tragedy Watts had been actively misleading Kessinger about the state of his marriage, telling her that he and Shawn were separated and that he was in the process of finalizing a divorce, that he was searching for a new apartment, and that he was essentially a free man building toward a new chapter of his life, none of which was true, and Kessinger would later tell investigators and reporters that she had genuinely believed these claims and had no knowledge that Sean N was pregnant or that the marriage was anything other than what's described to her. Sean N, for her part, had begun to sense that something was wrong with her husband in the weeks and months before her death, telling close friends that he was distant and cold, that he had expressed doubts about the marriage and about whether he wanted to continue in the relationship, and that his behavior had shifted in ways that alarmed her, and she confided these concerns to people she trusted, expressing uncertainty about the future of her family even as she continued to share cheerful content online, because Sean N was a person who invested deeply in the life she had built, and who was not willing to abandon it without exhausting every possible effort to understand what was happening and to find a path forward. On the evening of August 12, 2018, Sean N returned home from a business trip to Arizona, arriving at the family home in the early hours of the morning of August 13 while their daughters were asleep, and according to the account that Watts would give investigators in the days that followed, the couple had a conversation that morning about the state of their marriage, a conversation in which he told her he was not sure he wanted to continue the relationship. And it was in the aftermath of that conversation, in the bedroom of their home, that Watts committed the acts for which he would later accept responsibility before a court of law. The bodies of Sean N, Bella, and Celeste were not in the home when investigators arrived, and it would take the work of law enforcement, including agents from the Federal Bureau of Investigation and the Colorado Bureau of Investigation, to locate them, and when they were found it was at a remote oil field property owned by Anadarko Petroleum, where Watts worked, a location he had access to and had visited that same morning before his co-workers arrived for the day, and the precise circumstances of what happened in the hours between Shanann's return home and the discovery that the family was missing are documented in a detailed confession that Watts eventually provided to investigators, a confession in which he acknowledged his responsibility for the deaths of his wife and daughters and for the loss of his unborn son Nico, whose existence as a separate life the law would also recognize. In the immediate aftermath of the family's disappearance, Watts conducted himself in a manner that investigators and observers would later describe as deeply inconsistent with the behavior of a genuinely frightened husband and father, appearing on local television from the front porch of the family home to make a public appeal for the return of his wife and daughters, expressing that he was torn up inside and that he wanted everybody to just come home, and presenting to the cameras and to the nation an image of a distressed and confused husband while simultaneously, as investigators would establish through phone and digital records, exchanging text messages with Nicole Kessinger about their future together, asking her about vacation destinations, and behaving in communications with her in a manner entirely inconsistent with a man whose family had just vanished. The investigation moved quickly, driven by the work of Weld County law enforcement, the Colorado Bureau of Investigation, and the Federal Bureau of Investigation, and within days investigators had established through Watts's own employer records, a neighbor's security camera footage, and the digital trail left by his phone and communications that his account of events did not hold together, and on August 15, 2018, just 2 days after the family was reported missing, Christopher Watts was arrested and taken into custody, and shortly thereafter the remains of Sean N, Bella, and Celeste were located at the oil field site, with Sean N buried in a shallow grave and the girls' remains discovered in nearby oil storage tanks, and the medical examiner determined that Sean N, who was 15 weeks pregnant at the time of her death, died as a result of strangulation, while the girls died as a result of asphyxiation, and Weld County District Attorney Michael Rourke would later confirm at sentencing that Watts had acted deliberately and methodically, strangling Sean N for a period of at least 2 minutes, and then turning his attention to his daughters before loading their bodies into his work truck in a manner that the district attorney described as not hasty or disorganized but calm and methodical. The case proceeded rapidly through the legal system in part because of a decision made by Shanann's family, who communicated to prosecutors that they did not wish for the death penalty to be sought against Watts, a decision rooted in their own moral convictions rather than any sympathy for what he had done, with Shanann's mother Sandra Razusek later explaining simply that death was not her right to seek, and as a result Watts entered into a plea agreement under which he pleaded guilty on November 6, 2018, to 3 counts of first-degree murder, 2 additional counts of murder of a child, 1 count of unlawful termination of a pregnancy for the death of his unborn son Nico, and 3 counts of tampering with a deceased human body, and the sentencing hearing took place on November 19, 2018, at the Weld County Courthouse in Greeley, Colorado, before Judge Marcelo Kopkow, and what unfolded in that courtroom was a testament to the dignity and grief of a family that had been shattered by the actions of a man they had trusted with their lives. Shanann's father, Frank Rzusek, addressed the court and the man who had been his son-in-law directly, telling Watts that he had trusted him to take care of his daughter and grandchildren, and that Watts had instead treated them like trash, calling him a heartless monster and telling him that he did not deserve to be called a man. And Shanann's brother Frankie Rzusek Jr. asked through a statement read by the prosecutor what kind of person slaughters the people they love most. While Shanann's mother, Sandra, thanked law enforcement for their work and told Watts that he had broken the trust of everyone who had believed in him. And through each of these statements, Watts sat at the defense table with his head down, his leg moving restlessly, absorbing words that he would live with for the remainder of his life. Judge Kopkow, who had presided over thousands of criminal cases across 17 years on the bench, told the court that he could objectively say that the case before him was perhaps the most inhumane and vicious crime he had ever handled and that nothing less than the maximum sentence would be appropriate. And he sentenced Christopher Watts to 5 terms of life imprisonment without the possibility of parole, with 3 of those terms to be served consecutively, and additionally to 48 years for the unlawful termination of Shanann's pregnancy, and 36 years for the crimes related to the disposal of the remains. A combined sentence that ensured Watts would spend every remaining day of his life behind the walls of a maximum security prison. Watts was subsequently transferred in December of 2018 to the Dodge Correctional Institution in Waupun, Wisconsin, where he continues to serve his sentence, and in a jailhouse interview conducted in 2019, he acknowledged for the first time that the killings had been premeditated and that he had been planning to end his family's lives for several weeks before doing so, a revelation that removed any remaining ambiguity about whether the events of August 13th had been the product of a single terrible moment of impulse or of something far colder and more calculated. The Watts case sparked an enormous public response, driven in large part by the breadth of the digital record that Shanann and herself had created, because the videos and photographs she had shared over the years meant that millions of people felt they knew her and her daughters personally, had watched Bella and Cece grow up on a screen, had celebrated milestones with them from a distance, and the grief that followed the revelation of their deaths was consequently both widespread and deeply felt, and documentaries, podcasts, and films produced in the years since have continued to draw enormous audiences, a reflection of the enduring impact of a case that forced so many people to confront the reality that the most private and intimate spaces of domestic life can sometimes conceal the most profound suffering. Shanann's parents, Frank and Sandra Rzusek, became advocates for domestic violence prevention and victim support in the years following their daughter's death, channeling their grief into work that honors her memory and that seeks to prevent other families from experiencing what theirs endured. And the son that Shanann was carrying at the time of her death, who would have been named Nico Lee Watts, is remembered alongside his mother and sisters as a life that was taken before it had the chance to begin, and the 3 names, Sean and Bella and Celeste, remain in the public consciousness not as footnotes to the story of the man who harmed them, but as individuals whose lives mattered and whose loss continues to be mourned by people who never met them but who understood, through the joyful digital record Sean and left behind, exactly what was taken from the world on that August morning in Colorado. Number 2. Scott Peterson, the fisherman who came home alone. The disappearance of Lacey Denise Peterson on Christmas Eve of 2002 in Modesto, California, became one of the most widely covered criminal cases in American history, a story that unfolded over the course of more than a year on the front pages of newspapers and across the screens of cable news networks, drawing into its orbit millions of ordinary people who followed each development with a mixture of anguish and disbelief. And at the center of that story stood 2 figures whose lives had been intertwined since their college years and whose marriage had, by the end of 2002, arrived at a place that only one of them fully understood. Lacey Rocha was born on May 4, 1975, in Stanislaus County, California, and grew up in Modesto in a warm and close-knit family that described her as vivacious, outgoing, and deeply loving. A young woman who was enthusiastic about cooking and gardening, and who possessed the kind of natural warmth that drew people to her effortlessly. And she attended California Polytechnic State University, known as Cal Poly, where she met Scott Lee Peterson, a fellow student from a suburb near San Diego who was the youngest child in a large blended family, and who was described by those who knew him as charming, polite, and socially at ease. a young man who had briefly considered pursuing a professional golf career before redirecting his energies toward his studies. Scott and Lacey began a relationship at Cal Poly that deepened over the years that followed, and they married in August of 1997 in a ceremony that reflected the closeness of both their families, settling eventually in Modesto to be near Lacey's relatives, and Scott found employment as a fertilizer salesman, a career that took him regularly out of the area on business trips, while Lacey worked as a substitute teacher and later pursued her passion for cooking and homemaking, and by the spring of 2002 the couple had announced that Lacey was pregnant with their first child, a son they had decided to name Connor, and the pregnancy was a source of joy not only for Scott and Lacey but for both their extended families, who looked forward to the arrival of a child that would expand the bonds that tied them together. What Lacey did not know, and what the investigation would later establish in forensic detail, was that Scott Peterson had in November of 2002 entered into a romantic relationship with a 28-year-old massage therapist from Fresno named Amber Fry, whom he had met through a mutual friend, and that in the course of pursuing that relationship Peterson had told Fry that he was single, describing himself on one occasion as a man who had lost his wife, a statement that Fry would later explain she understood to mean he was a widower, and the profound cynicism of that particular lie, told by a man whose pregnant wife was still very much alive and who was preparing to celebrate Christmas with her family, would become one of the most discussed and damning elements of the case when it eventually came before a jury. On the morning of December 24, 2002, Scott Peterson told investigators that he had left the family home in Modesto to go fishing approximately 90 miles away at the Berkeley Marina, that Lacey had been planning to walk their golden retriever Mackenzie and do some household chores while he was gone, and that when he returned home that evening, he found Mackenzie in the yard still wearing a leash but no sign of Lacey, and after calling members of her family without success he contacted the Modesto Police Department, and within hours a missing persons search was underway that would eventually involve hundreds of volunteers, law enforcement agencies across multiple jurisdictions, and saturation media coverage that turned the Peterson family's Christmas into a national vigil. The search for Lacey continued through the winter and into the spring of 2003, and throughout that period Scott Peterson made public appearances that drew intense scrutiny from investigators and from the public, presenting himself as a devastated and confused husband while simultaneously, as investigators monitoring his communications established, maintaining his relationship with Amber Fry, who had by January of 2003 learned the truth about Peterson's identity and marital status after his name appeared in news coverage of Lacey's disappearance, and who then cooperated with law enforcement by allowing investigators to record her ongoing telephone conversations with Peterson, conversations in which Peterson continued to profess romantic intentions toward her and to discuss plans for their future together even as his pregnant wife remained missing. The breakthrough in the case came in April of 2003, when the remains of a woman and an infant were discovered washed ashore near the Berkeley Marina, the same body of water where Peterson had claimed to be fishing on the morning of Christmas Eve, and forensic examination confirmed that the remains were those of Lacey Peterson and her unborn son Connor, and investigators determined that the two bodies had been found approximately 1 mile apart on the shoreline of San Francisco Bay, in a location consistent with a scenario in which they had entered the water in the area where Peterson said he had been that morning, a geographical alignment that became one of the central pillars of the prosecution's case against him. Scott Peterson was arrested on April 18, 2003, by investigators who had been surveilling him after learning that he had traveled to San Diego, and when he was taken into custody authorities found in his vehicle a substantial amount of cash, multiple cell phones, camping equipment, his brother's driver's license, and a recently altered appearance that included bleached hair, a detail that prosecutors would later argue was consistent with someone preparing to flee rather than a man innocently mourning his missing wife. The trial of Scott Peterson began on June 1, 2004, in San Mateo County, California, after the proceedings were moved from Modesto due to concerns about the impossibility of selecting an impartial jury so close to the epicenter of the media coverage, and it ran for approximately 19 weeks, during which the prosecution presented 174 witnesses and hundreds of pieces of evidence in an effort to persuade the jury that Peterson had committed two first-degree murders, and the case was built almost entirely on circumstantial evidence, because investigators had no eyewitness to the crime, no identified murder weapon, and no definitive forensic evidence placing Peterson at the scene of his wife's death, a situation that the defense argued was itself proof of reasonable doubt, with Peterson's attorney Mark Garagos constructing an alternative theory in which Lacey had been encountered by strangers while walking the dog and that her death had been caused by unknown individuals who had later positioned her body in the bay after learning from news coverage where Peterson claimed to have been that morning. The most significant moment of the trial from a witness perspective came when Amber Frey took the stand in August of 2004 and testified about her relationship with Peterson, telling the jury that he had told her he was a widower and had lied consistently about his identity, his location, and his circumstances, and jurors were also played recordings of the telephone conversations between Frey and Peterson that she had allowed investigators to record, conversations in which the jury could hear Peterson's voice maintaining romantic deceptions even in the weeks after Lacey's disappearance had become national news, and the combined effect of Frey's testimony and those recordings on the jury's perception of Scott Peterson was described by legal observers as profound and difficult to overcome. After 7 days of deliberations that themselves became newsworthy when 2 jurors were removed and replaced by alternates under circumstances that generated additional legal controversy, the jury returned its verdict on November 12, 2004, finding Scott Peterson guilty of first-degree murder with special circumstances in the death of Lacey and guilty of second-degree murder in the death of their unborn son Connor. And the reading of the verdict was greeted by cheers from hundreds of people who had gathered outside the San Mateo County Courthouse to await the outcome, a public reaction that reflected both the intensity of the national investment in the case and the depth of feeling that had built up over the nearly 2 years since Lacey's disappearance. The penalty phase of the trial concluded on December 13, 2004, when the jury recommended the death penalty, and Judge Alfred DeLucci formally sentenced Peterson to death by lethal injection on March 16, 2005, ordering him transferred to San Quentin State Prison's death row, a sentence that Lacey's family publicly acknowledged was what they believed justice required even as Scott's family continued to maintain his innocence. The legal proceedings in the Peterson case did not end with that sentence, however, because the California Supreme Court took up an appeal in which Peterson's attorneys argued that errors in the jury selection process had resulted in a panel that was biased toward imposing the death penalty. And on August 24, 2020, the court agreed, overturning Peterson's death sentence while explicitly upholding his murder convictions, and the case was remanded to a lower court to determine the appropriate penalty, and in December of 2021, after Stanislaus County prosecutors announced they would not seek to restore the death penalty, Peterson was formally resentenced to life in prison without the possibility of parole, and he was subsequently transferred from San Quentin to Mule Creek State Prison, where he remains today. The Peterson case generated one additional significant development in 2024, when the Los Angeles Innocence Project, an organization dedicated to investigating potential wrongful convictions, announced that it had taken on Peterson's case and would be investigating what it described as a claim of actual innocence, filing in April of 2025 a petition for a writ of habeas corpus that argued exculpatory evidence had been destroyed or suppressed and that the prosecution's case had rested on conjecture rather than direct evidence. Though in June of 2025 a California appeals court denied that petition, and the legal pathway forward for Peterson's supporters remains narrow and uncertain. The federal passage in 2004 of the Unborn Victims of Violence Act, commonly referred to as Lacey and Connor's Law, which for the first time established in federal law that an unborn child is a separate victim in cases of violence against pregnant women, is one of the lasting legislative legacies of the case, and Lacey's mother Sharon Rocha became an outspoken public advocate for victims of violence and for better legal protections for pregnant women, channeling the grief of losing her daughter and grandson into work that has had measurable impact on American law, and the memory of Lacey Peterson, a 27-year-old woman who was 8 months pregnant and looking forward to the birth of her son when she disappeared on Christmas Eve, endures not as an adjunct to the legal history of her case but as that of a person who was deeply loved and who has never ceased to be mourned by those who knew her. Number 3. Drew Peterson, the officer who knew too much. There is a particular dimension of unease that attaches to cases in which the person under suspicion is themselves a member of law enforcement, because the knowledge and institutional familiarity that such a person carries can create obstacles to investigation that do not exist in ordinary cases, and the story of Drew Walter Peterson, a former sergeant with the Bolingbrook, Illinois, Police Department, illustrates that dimension with unusual clarity, because Peterson spent years existing in plain sight as a subject of public suspicion before the legal system finally reached a definitive conclusion about his conduct. and the case against him was assembled not through physical evidence or eyewitness testimony, but through a combination of forensic re-examination, the accounts of people to whom his victims had spoken their fears aloud, and a piece of legislation that the state of Illinois passed specifically in response to the evidentiary challenges. His case presented. Drew Walter Peterson was born on January 5, 1954, and grew up in Bolingbrook, a suburb of Chicago, where he enlisted in the United States Army after completing high school before returning home and joining the Bolingbrook Police Department in 1974, a career choice that would define both the trajectory of his life and the particular character of the investigation that would eventually consume it. Because Peterson was not merely a police officer but a sergeant, a person with decades of institutional knowledge about how investigations are conducted, what evidence is sought, and how scenes are interpreted by the people who arrive after a death is reported. Peterson was married 4 times over the course of his adult life, and his history with each of his wives traced an increasingly disturbing pattern, beginning with his first marriage to a high school sweetheart with whom he had 2 sons before divorcing after 6 years, and continuing through a second marriage to a woman named Vicki Connolly, from whom he separated after she discovered he was conducting an affair with a local accountant named Kathleen Savio. Kathleen Savio was a woman who had grown up near Bolingbrook, and her marriage to Drew Peterson in 1992, just months after his divorce from Connolly was finalized, began a relationship that would become increasingly difficult over the years that followed, with police being called to the Peterson home on numerous occasions for domestic disturbances, and Kathleen seeking a protective order against her husband in 2002, in a court filing in which she stated plainly that she feared her husband wanted her dead, and that she believed he would harm her, and in which she documented specific incidents and expressed a level of fear about her future that those who later reviewed those documents found deeply significant in retrospect. The marriage between Kathleen and Drew Peterson ended in divorce in 2003, and while their separation had formally concluded the legal relationship between them, it had not ended the financial entanglement, because a court was still in the process of determining the division of their marital assets at the time of the events that followed, and Kathleen was expected to receive a portion of Drew's police pension and other financial support from the settlement, a detail that prosecutors would later argue provided Peterson with a concrete financial reason to wish his former wife out of the picture entirely. On March 1, 2004, just months after their divorce was finalized, Kathleen Savio was found by a babysitter in her bathtub in her home in Bolingbrook, and the first responders who arrived determined that the bathtub was empty and dry at the time her body was discovered, and her hair was wet, and there was a gash on her scalp, and there was blood in the bathtub, and the initial investigation into her death was conducted in a manner that would later draw extensive criticism. With a coroner's inquest that included a police officer who personally knew Peterson and who reportedly assured other jurors of Peterson's good character, resulting in a finding of accidental drowning that closed the case and allowed Peterson to collect on Kathleen's estate, while Kathleen's own family immediately and consistently disputed the official conclusion and maintained that her death was not an accident. Drew Peterson remarried with remarkable swiftness, having during his marriage to Kathleen begun a relationship with a young woman named Stacy and Callis, who was 17 years old and 30 years younger than Peterson when they began seeing each other, and who had received her father's permission to date the still-married police sergeant. And the couple married in October of 2003, just months after his divorce from Kathleen was finalized. And together they had 2 children, and Stacy legally adopted Kathleen's children by Peterson and by all accounts invested genuinely in building a family life with him. But those close to her described a marriage in which the power dynamics were profoundly unequal, and in which Stacy's own fears about her situation grew over time in ways that she eventually began sharing with people she trusted. The case that had been closed with Kathleen Savio's death in 2004 was forcibly reopened by events in October of 2007, when Stacy Peterson was reported missing by her sister after she failed to maintain contact with her family, and Drew Peterson told investigators that Stacy had left him voluntarily to be with another man, an account that Stacy's family rejected entirely, pointing out that she would never willingly have abandoned her 2 young children. And as the search for Stacy Peterson generated national media attention, investigators began to examine afresh the circumstances of Kathleen Savio's death 3 years earlier, because the pattern of a police sergeant whose wife had died in unexplained circumstances and whose next wife had now disappeared struck investigators and legal observers as warranting far more scrutiny than the first death had originally received. Kathleen Savio's body was exhumed in November of 2007, and the results of a second forensic examination conducted by Dr. Michael Baden, a former New York City chief medical examiner, were unambiguous and directly contradicted the original finding, with Baden determining based on the nature and distribution of the injuries to Kathleen's body, which included extensive bruising to her back, torso, and face as well as the unexplained gash to her scalp, that she had died as a result of drowning following a physical struggle, and Will County State's Attorney James Glasgow subsequently announced that the death had been reclassified as a homicide that had been staged to appear accidental, and Drew Peterson was arrested and charged with the first-degree murder of his third wife. The trial of Drew Peterson, which took place in the summer of 2012 at the Will County Courthouse in Joliet, Illinois, presented the prosecution with an evidence problem of considerable complexity, because there was no physical evidence directly connecting Peterson to the scene of Kathleen's death and no eyewitness who had observed what happened in that bathtub, and the case rested critically on the accounts of what Stacey Peterson and Kathleen Savio had said to people they trusted about their fears and their suspicions and their knowledge of Drew Peterson. And the admission of that testimony required the application of a piece of Illinois legislation that had been passed in 2008 specifically because of the evidentiary challenges presented by this case, a law that became known informally as Drew's Law, which created a hearsay exception allowing the statements of unavailable witnesses to be introduced in court where a defendant's own conduct had caused the witness to be unavailable, meaning that if Peterson had caused Stacey's disappearance and Kathleen's death, then he could not benefit legally from the fact that neither woman could testify against him. The most critical testimony in the trial came from the Reverend Neil Scory, who had served as Stacey Peterson's pastor, and who testified that Stacey had confided in him that on the night Kathleen Savio was found dead, she had woken in the early hours of the morning to find her husband not in bed beside her, and that sometime later she had encountered him near the laundry area of their home dressed entirely in dark clothing and carrying a bag, and that he had placed the contents of the bag and his clothing into the washing machine and started a cycle, and that he had subsequently told Stacey that he had taken care of Kathleen and coached her on how to speak to police if they came asking questions. And a second witness, Harry Smith, who had been Kathleen Savio's attorney during her divorce proceedings, testified that Stacey had contacted him after Kathleen's death to ask whether Drew's role in Kathleen's death could be used as leverage in divorce proceedings of her own. Testimony that the jury described as extremely critical to their deliberations. On September 6, 2012, after approximately 14 hours of deliberations spread across 2 days, the jury found Drew Peterson guilty of the first-degree murder of Kathleen Savio, and the reaction in the courtroom and among Kathleen's family reflected years of grief that had finally found its formal acknowledgement, with Kathleen's brother Nick Savio telling reporters that someone had finally heard his sister's cry and that 12 people had done the right thing, while Stacey Peterson's sister Cassandra Callis told the press that the verdict should give courage to anyone who knew what had happened to Stacey and urged them to come forward, saying simply game over to the man who had dominated the lives of so many around him. Peterson was sentenced on February 21, 2013, to 38 years in prison, but the legal consequences for him did not end there, because while serving that sentence Peterson was found to have solicited the killing of the lead prosecutor in his case, and for that conduct he was sentenced to an additional 40 years, bringing the total length of his sentence to 78 years, and he remains incarcerated today, still having faced no formal legal proceedings. In connection with the disappearance of Stacey Peterson, who has never been found and whose case remains officially open, while her family continues to seek the truth about what happened to a young woman who entered into a marriage with a man she trusted and from whom she was never seen again. Number 4. Neil Entwistle, the husband who fled across an ocean. Among the cases that reveal the particular capacity of human beings for compartmentalization, for the ability to inhabit two entirely separate versions of reality simultaneously, the story of Neil Entwistle occupies a distinctive place, because what makes his case so striking is not simply the gravity of what occurred in a quiet house in Hopkinton, Massachusetts, on January 20, 2006, but the cold and deliberate nature of what came immediately after, as a man boarded a transatlantic flight and returned to his home country, while the bodies of his wife and infant daughter lay undiscovered in the bedroom of the home they had shared for only 10 days, and it would be left to Rachel's family and friends, who noticed her absence and grew concerned when she missed a doctor's appointment, to set in motion the search that would eventually lead investigators back to the house and to the terrible discovery that awaited them there. Neil Entwistle was born on September 18, 1978, in Worksop, a town near Nottingham in England, and grew up in a working-class household where his father worked as a coal miner and his mother as a cook at a school canteen. And he was by all accounts an academically capable young man who attended the University of York and earned a master's degree in electronic engineering, a credential that suggested a stable professional future and that made him, in the eyes of those who encountered him, a person of reasonable prospects and conventional ambition. It was at the University of York that Neil met Rachel Souza, an American woman who had come to England as part of a study abroad program, and the two began a relationship that would eventually lead to marriage, with the couple wedding in Plymouth, England, in August of 2003 after Rachel completed her studies and the two had built a relationship across the distance between their respective countries, and Rachel returned to England to be with Neil, where she worked as a teacher of English, drama, and theater studies at a Catholic school in Redditch while Neil worked in computing. And in April of 2005 their daughter Lillian Rose was born. And by all outward appearances the young family seemed to be on a settled and hopeful trajectory. The decision to relocate to the United States, to Rachel's home country and to be near her family, came in early 2006, and the Entwistles arrived in Massachusetts and initially stayed with Rachel's mother and stepfather, Joseph and Priscilla Matarazzo, in the town of Carver, before finding a 4-bedroom rented home in Hopkinton, a quiet community approximately 26 miles west of Boston, and they moved into that home in January of 2006 and had been living there for only 10 days when the events that would define Neil Entwistle's history took place within its walls. Events that Rachel's family and friends did not learn of for several days because there was no one in that rented house to tell them. The investigation into what had happened began when friends of Rachel's became concerned after she failed to appear for a scheduled doctor's appointment and could not be reached by telephone, and they contacted police, who initially conducted a check of the home and found nothing of concern, but returned on January 22, 2006, to conduct a more thorough search, and it was during that second search that investigators discovered the bodies of Rachel and 9-month-old Lillian in the master bedroom of the house, where they had been beneath the covers of the bed, and the medical examiner subsequently determined through autopsy that Rachel, who was 27 years old, had died as a result of a gunshot wound to the head, and that Lillian had died as a result of a gunshot wound to the torso, with the forensic evidence indicating that the bullet that struck Lillian had also passed through Rachel's body, and the investigation quickly focused on the firearm that had been used, which investigators traced to a .22 caliber handgun owned by Rachel's stepfather Joseph Matarazzo, a gun that Matarazzo told investigators was normally stored at his home in Carver and that had been missing in the days leading up to the discovery of the bodies. Neil Entwistle, meanwhile, was not in Massachusetts. In the early morning hours of January 21, 2006, the day before the bodies were discovered, Entwistle had arrived at Logan International Airport in Boston and purchased a one-way ticket on British Airways, departing at approximately 8:15 in the morning for London, and he was located by British authorities at a London Underground station shortly thereafter and was taken in for questioning, initially telling investigators that he had discovered the bodies of Rachel and Lillian himself on January 20th, had been overwhelmed and had not called emergency services or contacted Rachel's family, and had instead driven to Carver to return Matarazzo's firearm to its storage location before going to the airport and boarding a flight to England, an account that investigators found deeply inconsistent with the behavior of a grieving husband and father, and that served only to deepen their suspicion about his role in what had happened. The formal investigation that followed established through forensic analysis a direct connection between Matarazzo's firearm and the deaths of Rachel and Lillian, with ballistic evidence linking the weapon to the wounds found during autopsy, and the digital records of Neil Entwistle's computer activity in the period leading up to January 20th provided investigators with additional context about the state of his mind and his circumstances, because what those records revealed was a picture of a man under acute financial pressure, unable to find employment since arriving in Massachusetts, accumulating debt, and searching online in the weeks before his family's deaths for information about methods of ending life. Records that the prosecution would argue at trial were directly relevant to understanding what had occurred in that bedroom in Hopkinton. Neil Entwistle was extradited from the United Kingdom to Massachusetts in February of 2006, and was charged with 2 counts of first-degree murder, and he pleaded not guilty, and his defense team constructed a theory of the case that asked the jury to believe that Rachel had herself been responsible for Lillian's death before taking her own life, a theory that the defense argued explained the absence of a struggle the position of the bodies, and Neil's own strange behavior in the hours that followed, and defense attorney Elliot Weinstein argued in closing that Neil had discovered the bodies himself, had been overwhelmed by what he found, and had fled to his family in England because he was devastated and needed to be away, not because he was guilty. The prosecution rejected that account comprehensively, arguing through Assistant District Attorney Michael Fabry that the forensic evidence, the digital records, the flight behavior, and the financial context all pointed unambiguously to Entwistle as the person responsible for the deaths of his wife and daughter, and that a man who had been searching the internet for information about ending life in the weeks before his family's deaths, and who had purchased a one-way ticket to London in the hours after their bodies were found, was not a grieving husband but a person who had done something irrevocable and was attempting to place as much distance between himself and its consequences as possible. On June 25, 2008, the jury found Neil Entwistle guilty of 2 counts of first-degree murder, and he was sentenced on the following day to 2 consecutive terms of life imprisonment without the possibility of parole, a sentence that he has since unsuccessfully challenged on appeal, with the Supreme Judicial Court of Massachusetts rejecting his appeal in August of 2012 on the grounds that the warrantless searches of the family home had been lawfully conducted under the circumstances that existed when police first entered, and the United States Supreme Court subsequently declined to hear the case in January of 2013, exhausting the available avenues of appeal. Neil Entwistle continues to serve his life sentences at the Old Colony Correctional Center in Bridgewater, Massachusetts, while the parents of Rachel Entwistle, who have never accepted the alternative theory advanced by his defense and who have spoken publicly about their continuing grief, remember their daughter as a warm and engaged young woman who had embraced motherhood with joy and who was looking forward to building a life in the country she had grown up in, and the memory of 9-month-old Lillian Rose, who was too young to have done anything in the world except exist as the center of her mother's love, is held alongside that of Rachel as a reminder of what was taken in that quiet house in Hopkinton on a January morning when the person who was supposed to protect them chose instead to leave. Number 5. Oscar Pistorius. The Blade Runner and the Locked Door. Few criminal cases in recent decades have generated the volume of global attention, legal controversy, and public debate that surrounded the trial of Oscar Pistorius, a South African Paralympic and Olympic sprinter who had become one of the most celebrated athletes in the world before the events of the early morning of February 14, 2013 Valentine's Day, transformed him from an icon of human perseverance into a figure at the center of one of the most scrutinized criminal prosecutions in South African history, and the case raised questions that extended far beyond the facts of what happened in Pistorius's home in Pretoria that morning, touching on issues of gender-based violence, celebrity justice, the reliability of eyewitness and forensic evidence, and the capacity of a legal system to treat all defendants equally regardless of their public status. Oscar Leonard Carl Pistorius was born on November 22, 1986, in Sandton, South Africa, and was raised in a family that was marked early by both privilege and loss, with Oscar losing his mother when he was 15 years old, a bereavement that those who knew him described as having a profound and lasting effect on him, and from early in his life he faced the physical reality of having been born without fibulas in both legs, a condition that led to the amputation of both limbs below the knee when he was 11 months old, and yet it was precisely through that physical reality that Pistorius found his path to international recognition, because as a young man he embraced competitive running with a dedication and intensity that produced results of extraordinary quality, his carbon fiber prosthetic running blades earning him the nickname the Blade Runner and allowing him to compete not only in Paralympic competition but eventually, after a legal battle with the International Association of Athletics Federations in the Olympic Games themselves, where he competed at the London Olympics of 2012, becoming the first double amputee to participate in the Olympic Games, a milestone that generated enormous positive coverage and positioned him in the public imagination as a figure of almost mythological determination. Riva Steenkamp was born on August 19, 1983, in Cape Town, South Africa, and had built a career as a model and television personality, appearing in various media contexts and accumulating a following in her own right before she began a relationship with Pistorius in late 2012, a relationship that was still relatively new at the time of her death on February 14, 2013, when she was 29 years old, and those who knew her described a woman who was intelligent, warm, and committed to causes she believed in, including advocacy around issues of violence against women, a commitment that added a particular and painful dimension to the circumstances of her death. In the early hours of Valentine's Day morning, 2013, Oscar Pistorius fired 4 shots from a .9mm pistol through the closed and locked door of the toilet cubicle in the bathroom of his home in the Silver Woods estate in Pretoria, and Riva Steenkamp, who was inside that cubicle, was struck by 3 of those 4 bullets, suffering wounds to her right arm, right hip, and head, and she died at the scene despite Pistorius's subsequent efforts to carry her from the bathroom and seek medical assistance. And when paramedics arrived at the home, they found a scene that would become the subject of years of forensic analysis, legal argument, and public conjecture. Pistorius told investigators, and maintained consistently throughout the proceedings that followed, that he had woken during the night believing he heard a sound from inside the bathroom, that he had been frightened, that without his prosthetic legs he felt acutely vulnerable, and that he had retrieved his firearm from beneath his bed and approached the bathroom in genuine fear that an intruder had entered his home through the bathroom window, calling out to Riva to call the police before, in a moment of terror and without confirming who was behind the door, firing through the door of the toilet cubicle in what he described as a catastrophic error of judgment that he would spend the rest of his life regretting. The prosecution presented a sharply different account, arguing that the shooting had not been the product of a tragic mistake but of a volatile argument between Pistorius and Steenkamp that had preceded the fatal events, and pointing to several pieces of evidence in support of that theory, including text messages recovered from Riva's phone in which she had expressed to Pistorius that she was sometimes frightened of him and uncomfortable with how he responded when he was angry, as well as testimony from neighbors who reported hearing sounds from the direction of the Pistorius home in the hours before the shooting that they described as consistent with a heated argument. Testimony that the defense contested vigorously and that became one of the most disputed factual questions of the entire proceedings. The investigation itself was troubled from an early stage, with the lead detective, Hilton Botha, being removed from the case after it emerged that he himself faced legal difficulties, and with acknowledgments by investigators that certain aspects of the scene had not been handled in the manner that forensic best practice would require, and these investigative shortcomings provided the defense with material for challenging the reliability of the evidence and arguing that the conclusions being drawn from it were not as certain as the prosecution suggested. The trial took place before Judge Thokozile Masipa in Pretoria beginning in March of 2014, in proceedings conducted without a jury as a standard under South African law, and on September 12 of 2014 Judge Masipa delivered a verdict that acquitted Pistorius of murder but found him guilty of culpable homicide, a decision that was greeted with widespread public criticism in South Africa and internationally from legal scholars and commentators who argued that the judge had misapplied the legal doctrine of dolus eventualis, which holds that a person is guilty of murder if they foresee the possibility of causing death and proceed regardless, and that under a correct application of that doctrine the shooting of an unidentified person through a closed door constituted murder rather than culpable homicide. Pistorius was sentenced in October of 2014 to 5 years in prison for the culpable homicide conviction, and was released on parole in October of 2015 after serving approximately 1 year. But the state appealed both the verdict and the sentence, and in December of 2015 the Supreme Court of Appeal overturned Masipa's verdict, replacing it with a conviction for murder on the basis that Masipa had indeed misapplied dolus eventualis in reaching her original conclusion, and Pistorius was resentenced in July of 2016 to 6 years in prison, a term that the state again appealed as inadequate, and the Supreme Court of Appeal subsequently increased the sentence to 13 years and 5 months, bringing the effective time Pistorius would need to serve after accounting for time already spent in custody to approximately 13 years and 5 months from the date of the original conviction. After serving a period that combined his original incarceration and subsequent time behind bars, Oscar Pistorius was released on parole on January 5, 2024, having served approximately 8.5 years in total, and he remains under parole supervision until 2029, a supervision condition that reflects the court's view that his release into the community requires ongoing oversight, and the Steenkamp family, who throughout every stage of the legal proceedings maintained that Riva's death had not been the accident that Pistorius described, continue to grieve a daughter and sister whose life ended at 29 years old on a morning when, whatever the precise sequence of events, she was in a locked room and the person who had the firearm chose to fire it through the door. Number 6. Alex Murdaugh. The dynasty that destroyed itself. For generations, the Murdaugh family had been a defining institution in the Lowcountry region of South Carolina, a dynasty of attorneys and solicitors whose influence over the legal and civic life of the area was so deep and so long-standing that it had come to feel, to many in those communities, like simply the natural order of things. And Richard Alexander Murdaugh, known to everyone around him as Alex, was the latest inheritor of that legacy. A man who had grown up surrounded by the expectation of prominence and who had built his professional life within the shadow of his family's reputation, serving as a partner at the law firm that bore his family's name and living on a sprawling rural property called Moselle, a sprawling hunting estate in Culleton County that served as both a family retreat and a symbol of the standing that the Murdaugh name represented in the region. And it was on that property, on the evening of June 7, 2021, that Maggie Murdaugh and her younger son Paul were found dead. And the investigation that followed would reveal that the dynasty which had defined a region for nearly a century had been quietly consuming itself from within for years before that evening. Margaret Kennedy Murdaugh, known as Maggie, was 52 years old at the time of her death, a woman who had been married to Alex Murdaugh for more than 20 years and who was described by those who knew her as warm, devoted to her family, and deeply invested in the life they had built together at Moselle and in the surrounding community, while Paul Murdaugh, 22 years old, was the younger of the couple's two sons, a young man who had by the summer of 2021 been navigating his own legal difficulties stemming from his involvement in a fatal boating accident in February of 2019 in which a young woman named Mallory Beach had died, and whose trial on charges related to that incident was pending at the time of his death, a circumstance that would become relevant to the prosecution's theory of motive in the murder case that followed. On the evening of June 7th, Alex Murdaugh called emergency services to report that he had arrived at the dog kennels on the Moselle property and found his wife and son unresponsive. And when law enforcement arrived, they found Maggie and Paul had both suffered multiple gunshot wounds, with investigators determining that Maggie had been shot with a rifle and Paul with a shotgun. And Alex Murdaugh told investigators that he had been away from the kennels during the time when the deaths occurred, that he had visited his elderly mother and then returned to find them. And he maintained that account in the days and weeks that followed as investigators from the South Carolina Law Enforcement Division took charge of the case. The investigation proceeded for more than a year without an arrest, during which period Alex Murdaugh became the subject of scrutiny, not only in connection with the deaths of Maggie and Paul, but in connection with a separate and sprawling series of revelations about his professional conduct, because it emerged over the course of 2021 and 2022 that Murdaugh had for years been stealing from clients of his law firm, diverting settlement funds that should have been paid to people who had suffered genuine losses and directing that money to accounts he controlled, and that the total amount misappropriated over the years of this conduct ran to approximately $9 million. And as the scope of his financial crimes became clear to investigators and to the public, the portrait of a man who had conducted himself honorably within the traditions of his family's legacy collapsed entirely, replaced by an understanding of someone who had operated a sustained deception for years while presenting to the world the face of a respected and trusted professional. The critical break in the murder investigation came through technology that Alex Murdaugh had not accounted for, because the investigation established that Paul Murdaugh had recorded a short video on his mobile phone at the family's dog kennels on the evening of June 7th, at approximately 8:45 in the evening, and that video, which was recovered from Paul's phone, captured audio that multiple witnesses who knew Alex Murdaugh identified as his voice, placing him at the kennel at that time, which was only minutes before investigators established the deaths had occurred, a fact that directly contradicted the account Murdaugh had given to investigators about his movements that evening, and that meant the alibi he had offered was false. When Alex Murdaugh took the witness stand in his own defense at trial in February of 2023, he acknowledged for the first time that he had lied to investigators about his whereabouts, admitting that he had in fact been at the dog kennels shortly before Maggie and Paul were found there, and offering the explanation that he had panicked and lied in the immediate aftermath of discovering them because he knew that his history and his circumstances would make him the immediate focus of suspicion, and he maintained that despite lying about his alibi, he had not harmed his wife and son, and that the person or persons responsible for their deaths remained unidentified, a position his defense team had articulated throughout the trial by arguing that the evidence presented by the state, while circumstantial, was insufficient to establish his guilt beyond a reasonable doubt. The prosecution, led by Chief Prosecutor Creighton Waters, argued that the totality of the evidence pointed to one and only one person who had the motive, the means, the opportunity, and the established pattern of deception necessary to have committed the murders, and that the combination of the cell phone video placing Murdaugh at the scene, his false alibi, his years of financial fraud creating a desperate personal situation, his familiarity with the firearms that had been used, and the absence of any credible alternative suspect left the jury with only one rational conclusion. And after a trial that lasted 28 days and generated national media coverage, the jury deliberated for less than 3 hours before returning on March 2, 2023, with guilty verdicts on all 4 counts, 2 counts of murder and 2 counts of possession of a weapon during the commission of a violent crime, and Judge Clifton Newman, in declining a defense motion for a mistrial, stated that the evidence of guilt was overwhelming and that the circumstantial and direct evidence had pointed to a single conclusion that the jury had properly reached. Murdaugh was sentenced on March 3, 2023, to 2 consecutive terms of life imprisonment without the possibility of parole, and the case appeared to have reached its final legal resolution. But an extraordinary development in May of 2026 upended that conclusion when the Supreme Court of South Carolina overturned the convictions against Murdaugh on the grounds that the court clerk, Rebecca Hill, had engaged in improper conduct amounting to jury interference during the trial, and the court ordered that Murdaugh be granted a new trial, a ruling that does not represent a finding of innocence but rather a determination that the process by which the original verdict was reached was tainted in a manner that the legal system could not permit to stand. And as of the time of this documentary, Murdaugh's legal situation remains unresolved, with new proceedings pending and the families of Maggie and Paul Murdaugh facing the prospect of reliving the most painful chapter of their lives in a courtroom once more. Number 7. Mark Jensen. The Letter from the Grave. There are cases in which the most powerful testimony against a perpetrator comes not from a living witness but from a person who is no longer alive to speak, and the case of Mark Jensen is perhaps the most striking modern example of exactly that phenomenon, because the critical evidence that drove the prosecution of Jensen through more than 2 decades of legal proceedings, through 2 complete trials and multiple appeals that traveled all the way to the Wisconsin Supreme Court and into the federal court system, was a letter written by his wife Julie just 2 weeks before her death. A letter she handed to a neighbor for safekeeping, instructing that neighbor to give it to police if anything should happen to her, and in which she set out her fears about her husband and her belief that her life was in danger with a clarity and specificity that would prove as prophetic as it was heartbreaking, and the legal battles over whether that letter could be used as evidence became themselves a defining chapter in American evidentiary law, raising fundamental questions about the constitutional rights of defendants and the obligations of courts to those who cannot speak for themselves. Mark Jensen was a stockbroker living in the affluent lakeside community of Pleasant Prairie, Wisconsin, a suburb just south of Kenosha, where he and his wife Julie Carol Griffin Jensen had settled after marrying in the spring of 1984, building a life together that included 2 sons, David and Douglas, and a home in a neighborhood a block off Lake Michigan that reflected the financial success Mark had achieved in his professional career. And to those who observed the family from the outside, their life appeared comfortable and stable, though those who knew Julie more closely were aware of strains in the marriage that had accumulated over the years, including a brief romantic involvement that Julie had in 1991 with a coworker named Perry Terrica, an involvement that had ended but that Mark, according to testimony presented at both of his trials, had never truly forgiven, nursing a resentment that his own colleagues and associates would later testify had expressed itself in explicit conversations about his feelings toward his wife that went far beyond what could reasonably be described as marital frustration. What was also true about Mark Jensen by the autumn of 1998, though Julie either did not know it in full or was only beginning to understand it, was that he had been conducting an extramarital affair with a coworker at his brokerage firm named Kelly Labonte, a relationship that would continue after Julie's death and that would eventually lead to Mark and Kelly marrying, and that the existence of that relationship provided investigators and prosecutors with the clearest statement of motive for what they would allege Jensen had done to his wife, because the combination of his unresolved anger over Julie's affair, his ongoing involvement with another woman, and the prospect of a divorce that would require the division of significant marital assets created a set of circumstances that the prosecution would argue, across 2 decades and 2 trials, amounted to a recognizable and documented reason for a husband to want his wife out of his life permanently. In the weeks before her death, Julie Jensen was frightened, and she acted on that fear in the way that a thoughtful and deliberate person might, because she investigated her husband's movements, checked his planner, documented what she found, and reached out to people she trusted to share her concerns. And 2 weeks before she died, she sat down and wrote a letter addressed to police and gave it to her neighbor with the explicit instruction that it should be handed to authorities if anything happened to her. And in that letter she wrote that she prayed she was wrong and that nothing would happen to her, but that she was suspicious of her husband's behaviors and feared for what she called her early demise. And she stated clearly that she would never take her own life and that if she were found dead, police should consider Mark Jensen their first suspect. And it is difficult to read that letter without being struck by the courage it required, by the fact that Julie Jensen understood well enough what she feared to write it down and make provision for it, and that she was right. On December 3, 1998, Mark Jensen called emergency services and reported finding his wife unresponsive in their bedroom, telling investigators that she had been unwell for the previous 3 days with flu-like symptoms, but that he had not believed her condition was serious enough to warrant medical attention. And the initial response to Julie's death was inconclusive, because the first autopsy conducted by Kenosha County medical examiners was unable to determine definitively the cause or manner of death, and the case might have remained unresolved on that basis had investigators not seized the family's home computer and examined its browsing history, where they found a series of searches for information about the toxicity of ethylene glycol, the primary ingredient in antifreeze, conducted on the morning before Julie was reported dead, searches that no innocent explanation could account for and that shifted the investigation decisively. Because when a forensic toxicologist conducted additional blood tests on samples taken from Julie's body, the results came back positive for ethylene glycol, a substance that would have needed to be deliberately introduced into her system over a period of days for the concentrations found to have accumulated, ruling out any possibility that she had accidentally ingested it, and establishing that someone had been methodically and secretly giving it to her while she was alive and while she believed she was simply ill. The prosecution's theory, assembled from the computer searches, the toxicological findings, the testimony of a former colleague of Mark's named Ed Klug, who told investigators that Jensen had confided over drinks approximately a month before Julie's death that you could poison a spouse with antifreeze, and the account of a jailhouse informant named Aaron Dillard, was that Mark Jensen had over a period of days administered ethylene glycol to his wife through means she was unaware of, and had then, on the night of December 3, administered a sleeping medication to her as well and suffocated her in her bed after the combination of the antifreeze poisoning and the sedative had rendered her unable to resist, a method of causing death that forensic experts described to both trial juries as deliberate, premeditated, and the product of careful planning by someone who had researched their approach and understood precisely what they were doing. Mark Jensen was charged with first-degree intentional homicide in 2002, and his first trial took place in 2008 after years of pre-trial proceedings largely consumed by legal arguments over whether Julie's letter could be admitted into evidence. And the jury at that trial found Jensen guilty, and he was sentenced to life in prison without parole. But the conviction was challenged on appeal, with Jensen's attorneys arguing that the admission of Julie's letter violated his Sixth Amendment right to confront the witnesses against him since Julie was not alive to be cross-examined. And after years of further proceedings, the Wisconsin Supreme Court ruled in 2021 that Jensen was entitled to a new trial at which the letter would not be admitted, and a federal court had previously reached a similar conclusion through a habeas corpus proceeding. The second trial took place in January of 2023, and it presented the prosecution with the challenge of securing a conviction without the letter that had been so central to the first trial, and prosecutors built their case around the other evidence they had accumulated over 2.5 decades, focusing on the computer searches for ethylene glycol poisoning methods, the testimony of Ed Klug about Jensen's explicit statements regarding his wife, the forensic toxicological evidence, and the testimony of Kelly Labonte herself, who had by the time of the second trial divorced Jensen, and who provided the jury with a witness who could speak to the history of the marriage and the circumstances surrounding Julie's death from an intimate vantage point. And on February 1, 2023, after less than a single day of deliberations, the jury found Mark Jensen guilty for a second time, and Judge Anthony Milasoskas sentenced Jensen to life in prison without the possibility of parole on April 14, 2023. Noting the calculated and prolonged nature of the conduct and stating that Jensen was not receiving any parole eligibility because of the premeditated, researched, and purposeful evil that had characterized his crime, and Jensen is currently serving that sentence at the Dodge Correctional Institution in Waupun, Wisconsin, while Julie's family, who spent 25 years seeking justice for a woman who had done everything within her power to protect herself and to ensure that if the worst happened the truth would eventually be known. Continue to honor her memory and the remarkable foresight of a letter that spoke from beyond her death and refused to allow what was done to her to remain hidden. Number 8. George Joseph Smith, the Bluebeard of the Bath. To understand the case of George Joseph Smith, it is necessary to step back more than a century, to the early years of the 20th century in England, to a time when the technologies of forensic investigation were still in their early development and when a sufficiently charming and calculating individual might exploit the limitations of that era's investigative capacity across multiple jurisdictions and over a period of years before anyone connected the patterns that, in retrospect, were hiding in plain sight. And the story of Smith is in one sense the story of how the emerging discipline of forensic pathology came of age through the determined work of a detective and a scientist who refused to accept that 3 young women had simply had the misfortune to drown in their bathtubs. And in another sense it is the story of Bessie Mundy, Alice Burnham, and Margaret Lofty, 3 women whose lives were taken through a method so deliberate and so carefully obscured that it required the application of genuine scientific innovation to establish what had happened to them. George Joseph Smith was born on January 11, 1872, in Bethnal Green, London, the son of an insurance agent, and from early in his life demonstrated a pattern of behavior involving deception and the exploitation of others, being sent to a reformatory at the age of 9 and subsequently serving multiple periods of imprisonment for offenses including fraud and theft before eventually channeling his considerable natural aptitude for manipulation in a direction that would prove far more consequential than ordinary criminality. Smith was a man of significant personal magnetism, described by those who encountered him as possessing an unusual ability to charm and influence women in particular, and it was this quality that he developed into what amounted to a deliberate methodology, because beginning around 1908 Smith embarked on a pattern of conduct in which he would identify vulnerable women, typically those who were somewhat isolated, financially independent, and susceptible to romantic attention, and would pursue them with focused and convincing courtship, eventually persuading them into bigamous marriages conducted under one of the several aliases he maintained, including Henry Williams and John Lloyd, before engineering situations in which he could access their financial assets and, in the most extreme instances, ensure that they could not survive to dispute his account of what had occurred. The earliest victims of his financial predation were women whom he robbed through the mechanism of the false marriage itself, persuading them to give him access to their savings or valuables before disappearing from their lives, sometimes with a note blaming them for some invented transgression, and in one particularly cynical instance abandoning a bride at the National Gallery of Art in London after a visit to the galleries, slipping away while she waited for his return and taking with him the money and jewelry he had persuaded her to make available during their brief time together. And it was the efficiency of this approach that apparently convinced Smith that an even more reliable method existed for obtaining the financial benefits of marriage while avoiding its ongoing obligations, a method that required the woman to be permanently unavailable rather than merely defrauded and abandoned. Bessie Constance Mundy was 31 years old when she met Smith in Weymouth, England in 1898, a single woman whose finances were managed for her in a trust fund by her uncle and which contained approximately £2,500 in assets, and Smith married her in August of 1910 using the name Henry Williams, but after discovering that he could not simply demand or remove the trust funds, which were structured specifically to prevent exactly that kind of access, he abandoned Bessie after appropriating the liquid cash she had available, leaving a note blaming her for the failure of their relationship. And it was not until 2 years later, when Bessie encountered Smith by apparent accident on the seafront at Weston-super-Mare, that he returned to her life, convincing her through the same charm that had worked before to take him back and resume their relationship. And this time Smith moved with deliberate purpose, taking Bessie to Herne Bay Inn, Kent, arranging for the couple to draw up mutual wills naming each other as sole beneficiaries, and then visiting a local doctor with his wife, where he described to the physician symptoms he claimed Bessie had been experiencing, establishing a medical record of illness that would serve as a foundation for the explanation he intended to offer. And on July 13, 1912, Bessie Mundy was found dead in the bathtub of the home they were renting, and the inquest that followed accepted Smith's account that she had suffered an epileptic fit while bathing and had drowned as a result, and the coroner recorded a verdict of death by misadventure, and Smith collected the inheritance and departed. Alice Burnham was 25 years old when she married Smith in Portsmouth in November of 1913, under the name George Smith, and her father Charles Burnham had expressed serious reservations about his prospective son-in-law from the beginning of their acquaintance, describing him during the engagement as being of very evil appearance, a description that in hindsight captures something real about what he was perceiving in the man his daughter intended to marry. But the wedding went ahead nonetheless, and Smith and Alice traveled to Blackpool for what amounted to a honeymoon, staying in rooms operated by a landlady named Mrs. Crossley, and Alice Burnham died in her bath on December 12, 1913, just weeks after her marriage, and the inquest again recorded a verdict of accidental death, with the conclusion that she had drowned after suffering heart failure while in the bath, and Smith again inherited his wife's estate and insurance policy, valued at £500, and moved on. Margaret Elizabeth Lofty was the third woman to marry Smith, doing so in December of 1914 using the alias John Lloyd, in a ceremony in London, and on the afternoon of December 18th, the day after their wedding, Margaret visited a solicitor and made a will leaving her estate to her husband, and that evening a neighbor at the boarding house where they were staying heard sounds of movement from above, and then the music of a hymn being played on the property, and then the sound of the front door, and when John Lloyd returned to the house he reported that he had been out purchasing tomatoes for his wife's supper, and had returned to find the bathroom door open and his wife unresponsive in the bath, and Margaret Lofty was declared dead by the doctor who arrived, with accidental drowning recorded as the cause, and Smith told those around him that he hoped the verdict would not be suicide as he would not want it said his wife had been unwell of mind, and then collected his inheritance and prepared to move on once more. But this time something different happened. Joseph Crossley, who had been the landlord in Blackpool when Alice Burnham died, read a brief newspaper report about the death of Margaret Lofty in London and was struck by the almost exact similarity between the two incidents, and he wrote to the Metropolitan Police to draw their attention to the parallel, and Charles Burnham, Alice's father, read the same report and contacted police independently, and the combination of these two communications reached Detective Inspector Arthur Neal of the Metropolitan Police, who reviewed the information and saw in it a pattern that he believed warranted serious investigation, and who set about the work of establishing whether John Lloyd and George Smith were the same person, and whether the deaths of Margaret Lofty, Alice Burnham, and Bessie Mundy were connected not by coincidence but by deliberate human agency. Inspector Neal located Smith at his solicitor's office where he had come to collect the proceeds of Margaret Lofty's estate, and confronted him with questions about Alice Burnham's death and his possible identity as John Lloyd. And Smith's initial denials collapsed quickly when Neal made clear that the information he possessed was more extensive than Smith had anticipated, and Smith was detained and subsequently charged with murder, and the investigation that followed required not only the assembly of evidence about 3 deaths in 3 separate locations but the development of an explanation for how those deaths had been brought about, because none of the 3 women had shown signs of the kind of physical harm that typically accompanies a death by violence, and yet none of them had been in poor health, and the challenge of explaining how a man had drowned 3 healthy women in bathtubs without leaving conventional evidence of how it had been done fell to the forensic pathologist Dr. Bernard Spilsbury, who would later become one of the most celebrated figures in the history of British forensic science, and who approached the problem with a combination of scientific rigor and creative thinking that would produce both the answer to the question and one of the most dramatic demonstrations ever conducted in the service of a prosecution. Spilsbury's investigation, conducted through the exhumation and examination of all 3 bodies, confirmed that each woman had died as a result of drowning, and his extensive work on the problem of how it had been accomplished led him to a theory that he verified through direct experimentation, in which Detective Inspector Neal participated by recreating the conditions in a bathtub with the assistance of a nurse in a bathing costume, and the demonstration showed that if a person in a bath was subjected to a sudden and forceful lifting of the legs, the resulting movement would cause the upper body to be submerged almost instantaneously and would produce such an immediate physiological shock that unconsciousness followed within moments, too quickly for the person to cry out or to resist, and the accuracy of this theory was dramatically confirmed during the demonstration when the nurse herself lost consciousness and had to be urgently removed from the water and resuscitated. The near tragedy of that moment serving only to underline for Neal and his colleagues the precision with which Smith had apparently refined his method across 3 applications. The trial of George Joseph Smith opened at the Old Bailey in London in June of 1915, and the prosecution was permitted by the judge to introduce evidence of all 3 deaths even though Smith was formally charged only with the murder of Bessie Mundy, on the grounds that the striking similarities between the 3 incidents demonstrated a system of conduct that was relevant to the question of whether Bessie's death had been accidental or deliberate, a ruling that established a legal precedent regarding the use of similar fact evidence that would influence criminal proceedings in England and beyond for generations to come, and the 3 bathtubs in which the women had died were brought into the courtroom as physical exhibits, a detail that captured the public imagination and contributed to the sensation that surrounded the trial, while Bernard Spilsbury testified about his forensic findings and his experimental demonstration, and the jury, after hearing all the evidence presented over the course of the proceedings, deliberated for only 22 minutes before returning a verdict of guilty, a speed of deliberation that reflected the clarity with which the evidence had established Smith's responsibility for what had happened to each of his wives. George Joseph Smith was sentenced to death and was executed by hanging at Maidstone Prison on August 13, 1915, and the Brides in the Bath case, as it had been named by the press, left behind it a legacy that extended well beyond the confines of the criminal proceedings themselves, because the forensic techniques developed and demonstrated by Bernard Spilsbury in the course of investigating the deaths of Bessie Mundy, Alice Burnham, and Margaret Lofty became foundational contributions to the developing science of forensic pathology, with Spilsbury going on to a career that earned him a knighthood and the reputation of the foremost forensic expert of his generation. And the legal precedent established by the judge's ruling on similar fact evidence continued to shape how courts in England approached the question of when the pattern of a defendant's conduct could be used to illuminate a specific act with which they were charged, and Smith himself remained for decades a figure of considerable public fascination, his waxwork appearing in the Chamber of Horrors at Madame Tussauds and his case referenced in works by writers including Agatha Christie, Evelyn Waugh, and Harold Nicholson, not because there was anything admirable in what he had done but because the story of how he was caught, through the persistence of a detective, the innovation of a scientist, and the chance intervention of people who had read a newspaper and recognized a pattern, continued to stand as a testament to the capacity of determined investigation to reach the truth even when a perpetrator has done everything within their power to conceal it. Number 9. Robert Alan Durst. The heir who bought his way out of everything. There is a particular category of criminal case that forces a society to confront one of the most uncomfortable truths about the relationship between wealth and justice, and the story of Robert Alan Durst is perhaps the most complete and most troubling illustration of that truth that the American legal system produced in the 20th and early 21st centuries, because Durst was a man who by any objective assessment left a trail of death, deception, and deliberate obfuscation stretching across 4 decades and 3 states. A man who was suspected of causing the death or disappearance of at least 3 people over the course of his adult life, and who nonetheless managed through a combination of extraordinary inherited wealth, aggressive legal representation, and the kind of institutional deference that attaches itself to prominent family names to avoid formal accountability for nearly 40 years, until a documentary film crew, a hot microphone, and his own unshakable belief in his own impunity finally undid him at the age of 78. Robert Alan Durst was born on April 12, 1943, in New York City, the eldest son of Seymour Durst, the patriarch of one of the most powerful real estate dynasties in Manhattan's history, a family whose holdings would eventually include a significant portion of the commercial property in Midtown New York, and whose wealth and influence within the city's political and civic life gave the Durst name a weight that translated directly into the kind of insulation from ordinary consequence that most people will never experience and that Robert would draw upon repeatedly across the decades that followed. Those who knew Robert Durst in his early years described a young man who was marked from childhood by a defining and traumatic event, having witnessed as a child of 7 the death of his mother Bernice, who fell from the roof of the family home in Scarsdale, New York, in circumstances that were officially ruled accidental but that Robert's own siblings would later describe in interviews as having profoundly destabilized him, and the lasting psychological impact of that early loss, combined with what those closest to him described as his father Seymour's emotional coldness and the enormous pressure that came with being the heir apparent to a real estate empire, shaped a personality that his acquaintances and later his prosecutors would characterize as narcissistic, controlling, and fundamentally unable to accept constraint from any external source. In the late 1960s, while studying at Lehigh University in Pennsylvania and later at UCLA, Robert Durst met Susan Berman, the daughter of a Las Vegas organized crime figure named Davy Berman, and the two formed a close friendship that would last for more than 3 decades and that would, in the end, cost Berman her life, because it was the particular nature of what she knew about Robert and what she had done on his behalf in the years following the disappearance of his wife that made her both his most important protector and, eventually, a liability he calculated he could not afford. In the autumn of 1971, Durst met Kathleen McCormick, a young dental hygienist from a large, warm, working-class family on Long Island who was 19 years old at the time, and who would later describe to friends and family a relationship that began with apparent passion and care before gradually revealing itself to be something much darker. And the couple married on April 12, 1972, in a ceremony that reflected the considerable difference in their backgrounds and that placed Kathy, as she was known to those who loved her, into the world of New York wealth and privilege that her husband inhabited. Over the years that followed, Kathy McCormick Durst pursued her own ambitions with a determination that those who knew her found admirable, and that her husband found increasingly intolerable, enrolling first in nursing school and then in medical school at the Albert Einstein College of Medicine in the Bronx, where she was in her final year of study and just months from earning her degree as a physician when the events of January 31, 1982, brought her life to an end. And though the precise circumstances of what happened on that evening at the couple's weekend home in South Salem, New York, were never established in a court of law due to the decades it took the legal system to formally charge Robert Durst with her murder, the investigative report released by the Westchester County District Attorney in January of 2022, following Robert's death, concluded with the statement that there was absolutely no doubt that he had killed her in Westchester County on January 31, 1982, and that the evidence supporting that conclusion had been available for nearly 40 years. What Durst told investigators at the time was that he had driven Kathy to the train station on the evening of January 31, so she could return to Manhattan for medical school the following morning, and that he had spoken to her by telephone after she arrived at their apartment, and that he had only reported her missing 5 days later when she failed to appear at school, a timeline that directed the initial investigation toward Manhattan and away from South Salem. And it was years before investigators established through the accounts of multiple witnesses that Kathy had never arrived in Manhattan that evening and that Durst's account of a telephone call was itself fabricated, a deception he would eventually acknowledge during his own trial testimony decades later, when he admitted he had made up details about the events of that night in the hope that it would all just go away. Susan Berman played a specific role in the immediate aftermath of Kathy's disappearance that would take investigators decades to fully understand, with prosecutors establishing at trial that it was Berman who had contacted Kathy's medical school on the day after her disappearance to report that Kathy was unwell and would not be attending class, a call that provided Robert with the appearance of a wife who was still alive and communicating after the point at which investigators believe she had died, and Berman herself told friends over the years that she knew what had happened to Kathy and had helped cover it up, a confidence she shared with people she trusted while simultaneously understanding that her own continued safety depended on maintaining Robert's, a calculation that ultimately proved catastrophically wrong. For the next 18 years following Kathy's disappearance, Robert Durst lived a life of escalating eccentricity and legal difficulty, secretly divorcing Kathy in 1990 without informing her family and inheriting from her estate, developing an increasingly bizarre pattern of behavior that included disguising himself and living under assumed identities in various locations, and navigating investigations into his activities with the assistance of the legal resources that his inherited wealth made available to him, while Kathy's family, led by her brother Jim McCormick and her sisters, continued to push for answers that the legal system seemed consistently unable or unwilling to provide. And her brother would tell journalists decades later with absolute certainty that Robert Durst had killed his sister in 1982, and that the evidence had always been there for those willing to look. The murder of Susan Berman in December of 2000 was the act that would ultimately bring Robert Durst before a jury, because Berman was killed at a moment when Westchester County investigators had reopened the inquiry into Kathy's disappearance and had been preparing to fly to Los Angeles to interview her, and the prosecution would argue at trial that Durst shot Berman in the back of the head in her Beverly Hills home on or around December 23, 2000, not out of malice toward a longtime friend, but out of the cold calculation that she represented the one person most capable of providing investigators with direct knowledge of his role in Kathy's death, and that silencing her was therefore a necessary act of self-preservation, and the fact that no signs of forced entry were found at Berman's home, and that a handwritten note directing police to her address with the word cadaver written in capital letters was sent anonymously to the Los Angeles police were both pieces of evidence that the prosecution would weave into a comprehensive account of a man who committed murder in a deliberate and organized manner, and who believed his own wealth and intelligence placed him beyond the reach of accountability. The events of 2001 in Galveston, Texas, added another layer of extraordinary complexity to Robert Durst's legal history, because having fled New York after Behrman's murder became the subject of an investigation. Durst disguised himself as a mute woman and rented a room in a low-income boarding house in Galveston, where his neighbor, a 71-year-old man named Morris Black, was subsequently found dismembered in Galveston Bay, and Durst was arrested and charged with Black's murder but mounted a defense at trial in which he claimed that Black had been shot accidentally during a struggle and that he had then dismembered and disposed of the body in a panic. And an acquittal by the Galveston jury in 2003 shocked legal observers and reinforced the perception held by many that Robert Durst's money had once again purchased an outcome that an ordinary defendant would not have obtained. The instrument of his eventual undoing was one he had chosen himself, because Durst agreed to participate in an HBO documentary series titled The Jinx. The Life and Deaths of Robert Durst, directed by Andrew Uretsky, apparently motivated by the belief that he could once again shape the narrative in his favor, and the documentary, which aired in February of 2015, presented evidence that investigators had not previously had access to, including a letter Durst had written to Susan Berman that contained the same distinctive misspelling of Beverly Hills as Beverly Hills that appeared on the anonymous cadaver note sent to police after her death. A connection that the documentary confronted Durst with directly in a filmed interview in which his composure visibly fractured. And in the final episode of the series, Durst was caught on a live microphone in a bathroom, apparently unaware he was still being recorded, muttering to himself words that included the phrase "killed them all," of course, a statement that prosecutors would characterize at trial as a confession and that Durst's defense would argue was taken out of context and represented a fragment of a longer internal monologue. Durst was arrested in a New Orleans hotel room on March 14, 2015, the night before the final episode of The Jinx was scheduled to air, and the ensuing legal proceedings were delayed extensively by a combination of Durst's deteriorating health, which required him to appear in a wheelchair throughout much of his trial, and the interruptions caused by the global pandemic of 2020. But the trial of Robert Durst for the murder of Susan Berman finally opened in Los Angeles County Superior Court in the spring of 2021, before Judge Mark Wyndham, who had declared before proceedings began that he had never seen a more interesting case in his career, and the prosecution was led by Deputy District Attorney John Lewin, who, over the course of a trial in which more than 80 witnesses testified and nearly 300 exhibits were entered into evidence, constructed an argument that intertwined the murder of Berman with the suspected death of Kathy Durst and the Galveston killing as constituent parts of a single continuous pattern of criminal conduct by a man who disposed of people who threatened him and who was sustained in his ability to do so by wealth, narcissism, and a lifetime of impunity. When Durst took the witness stand and was subjected to cross-examination by Lewin over the course of nearly 40 hours, the extraordinary endurance of that examination wearing down his carefully maintained composure, he admitted for the first time under oath that he had written the anonymous cadaver note directing police to Behrman's body, and that he had been in Los Angeles at the time of her death, both of which he had previously and adamantly denied. And Lewin's closing argument told the jury that they were looking at a narcissistic psychopath who had murdered Susan Berman, and that they must not allow him to escape accountability once more. And the jury, which had deliberated over the course of 3 days, returned on September 17, 2021, with a verdict of guilty of first-degree murder, finding that the prosecution had proven beyond a reasonable doubt that Robert Durst had shot Susan Berman in her Beverly Hills home on or around December 23, 2000. Durst was sentenced to life imprisonment without the possibility of parole in October of 2021, and just days after his sentencing he was formally indicted in Westchester County for the second-degree murder of Kathleen McCormick Durst, a development that her family had waited nearly 40 years to see, and Robert Durst died in custody on January 10, 2022, at the age of 78 of congestive heart failure and other complications, and under California law his Berman conviction was technically vacated after his death because his appeal was still pending, a legal technicality that his family had to contend with alongside their grief, while Kathy's family released a statement making clear that no legal technicality altered their certainty about what Robert Durst had done to their sister, a certainty endorsed by the Westchester County District Attorney's investigative report released in January of 2022, which concluded that Robert Durst had killed Kathleen McCormick in South Salem, New York on January 31, 1982, and that the evidence supporting that conclusion had existed for 4 decades while wealth, influence, and institutional failure conspired to prevent the law from reaching him. Number 10. John Edward Robinson Sr. The family man who hid monsters in barrels. The story of John Edward Robinson Sr. presents a portrait of an individual whose entire adult life was constructed around the deliberate and sustained maintenance of two entirely separate identities that existed in complete contradiction of each other. Because on one side of that divide stood the Robinson that his community, his church, his family, and his professional acquaintances believed they knew, a church-going suburban grandfather with a friendly manner and a talent for self-promotion, who sat on charitable boards, organized civic events, and presented to the world around him the picture of a respectable family man. And on the other side stood an individual with a documented history of financial fraud spanning decades, who eventually extended his criminal conduct in directions that would not become publicly known until the year 2000, when investigators searching properties Robinson owned in Kansas and Missouri discovered the remains of women who had been concealed in chemical barrels, and who established over the course of what would become the longest criminal trial in Kansas history that Robinson had been systematically targeting, exploiting, and causing the deaths of vulnerable women across a period of at least 16 years, making him not only a convicted murderer but a figure of unique and sinister historical significance as the first documented serial killer known to have used the internet as a primary tool for identifying, grooming, and isolating his victims. John Edward Robinson was born on December 27, 1943, in Cicero, Illinois, the third of 5 children in a household his biographers have described as marked by an alcoholic and abusive father and a strict, disciplinarian mother. And from early in his life he displayed a pattern of behavior that combined surface charm with a consistent willingness to deceive, being dismissed from the Quigley Preparatory Seminary in Chicago after disciplinary difficulties and leaving Morton Junior College in Cicero without completing his studies, before eventually relocating to Kansas City in 1964, where he married Nancy Jo Lynch and began building the suburban family life that would serve for decades as the external cover for everything else he was doing. The marriage to Nancy and the family it produced, which included a son named John Robinson Jr. and a daughter named Kimberly and then twins named Christopher and Christine, was in one sense the most important prop in the performance Robinson staged for the world around him, because the existence of a stable family unit with a long married wife and 4 children conferred on Robinson a kind of social legitimacy that repeatedly helped him survive the legal and professional consequences of behavior that would otherwise have ended his public standing entirely. And Nancy Robinson, who divorced her husband only after his arrest in 2000 following 36 years of marriage, has been described by those who knew her as a woman who was genuinely unaware of the full scope of what her husband was doing behind the facade he maintained for their family, a position that legal proceedings and journalistic investigations never found reason to challenge. The documented history of Robinson's criminal conduct before his murders began reveals a man whose fundamental mode of operating was fraud and deception deployed with patience and confidence, because from 1969 onward he accumulated a record of embezzlement, check forgery, theft, and confidence schemes that resulted in multiple criminal convictions and periods of incarceration across the 1970s and 80s, and throughout each of these legal difficulties he demonstrated a consistent ability to reinvent himself professionally and socially, obtaining positions of apparent trust and then exploiting them, forging letters of reference from public officials including the mayor of Kansas City, and in one particularly brazen instance arranging to have himself named Man of the Year by a charitable organization whose board he had infiltrated using forged commendation letters, a story that encapsulates the precise mechanism by which Robinson operated throughout his life, because his success in each new deception depended on the credibility established by the previous performance. The first of Robinson's victims whose disappearance investigators eventually connected to him was a 19-year-old woman named Paula Godfrey, who vanished in 1984 after agreeing to work as a sales representative for one of Robinson's fraudulent shell companies, and whose disappearance was investigated without resolution because Robinson produced letters he claimed were from Godfrey saying she was fine and had chosen to move on. Letters that investigators later established were forged using blank stationery he had persuaded her to sign before her disappearance, a technique of posthumous deception that Robinson would refine and employ repeatedly across the following years to create the impression that women he had caused to disappear were alive, well, and communicating voluntarily with their families, a mechanism that simultaneously bought him time and placed the investigative focus on questions of whereabouts rather than questions of survival. The case of Lisa Stasi in January of 1985 illustrates with particular clarity the compounded harm that Robinson's conduct created. Because Stasi was a 21-year-old woman with a 4-month-old daughter named Tiffany, who was staying at a shelter for women in difficult circumstances in Kansas City, when Robinson approached her with an offer of employment, an apartment, and assistance with childcare, presenting himself as a philanthropist with connections to organizations that helped young mothers in need, and Stassi agreed and brought Tiffany with her when she departed with Robinson, and was never seen again. And what Robinson did in the days that followed her disappearance was to contact his own brother Donald and Donald's wife, Helen Robinson, who had been trying without success to adopt a child, and to present them with Tiffany, telling them that he had arranged a legitimate adoption through legal channels and collecting from them a fee for his services, providing what appeared to be authentic adoption papers bearing the forged signatures of 2 attorneys and a judge. And the Robinson family accepted the child and raised her as their daughter, naming her Heather Robinson. And it would be 15 years before the truth of Heather's origins would be established through DNA testing conducted after Robinson's arrest in 2000, at which point Heather Robinson learned not only that her biological mother had been one of her adoptive uncle's victims, but that the man she had known as Uncle John had caused her mother's death before handing her to his own family as a commodity acquired through murder. A revelation whose impact on Heather Robinson's life has been the subject of subsequent documentary coverage, and that represents one of the most viscerally disturbing dimensions of Robinson's overall conduct. The years between 1985 and his arrest in 2000 saw Robinson continue his pattern of targeting vulnerable women in various circumstances, including Beverly Bonner, a 49-year-old prison librarian he met while serving a sentence at the Western Missouri Correctional Facility, whom he persuaded after his release to leave her husband and relocate to Kansas City to work for him in one of his companies, after which her family lost contact with her entirely while Robinson continued to cash the alimony checks her mother forwarded to a post office box on her behalf, a continuation of the deceptive correspondence technique that kept investigators' attention directed away from him and toward the question of where the women had gone rather than what had happened to them. The development that gave Robinson both a new hunting ground and the historical distinction that has since attached to his case was the emergence of the Internet in the early 1990s, because Robinson, who was by that point in his late 40s and possessed of a lifetime's practice in identifying and exploiting the vulnerabilities of people seeking help or connection, recognized immediately the potential of online communication platforms as a means of meeting women who could be targeted, and he began operating in internet chat rooms and online communities dedicated to bondage and domination under the username Slavemaster, presenting himself as a wealthy businessman with specific interests and building relationships with women who were drawn to the dynamic he presented. And it was through this online presence that he made contact with Isabella Luica, a 21-year-old Polish immigrant student who moved to the Kansas City area to be with Robinson after developing an online relationship with him in which she agreed to assume the role of his slave in a documented arrangement he formalized through a written contract, and Suzette Troughton, a 27-year-old Michigan woman who also relocated to Kansas City after corresponding with Robinson online, and who also disappeared after arriving to be with him, and it was the missing persons report filed by Troughton's family in the spring of 2000 that finally set in motion the sequence of investigative steps that would end with Robinson's arrest in June of 2000 and the discovery of the barrels. When investigators executing search warrants on Robinson's properties in Kansas and Missouri in the summer of 2000 opened the containers they found on his rural farm in Lynn County, Kansas, and in a rented storage facility in Raymore, Missouri, they discovered the remains of 5 women concealed inside heavy chemical drums, and subsequent forensic work established that the women in those barrels were Suzette Troughton and Isabella Luica, found in Kansas, and Beverly Bonner, Sheila Faith, and Sheila's 15-year-old daughter Debbie Faith, who had been wheelchair-dependent due to spina bifida, and who had traveled with her mother to Kansas City after Robinson persuaded Sheila that he would pay for Debbie's medical expenses and provide employment for both of them, and the discovery of Debbie Faith's remains alongside those of her mother added to the case a dimension of particular gravity in that the youngest identified victim had been a disabled teenager who had traveled across the country with her parent in the belief that a stranger's offer of help was genuine. The trial of John Edward Robinson Sr. in Kansas began in 2002 and ran for a period that made it the longest criminal trial in Kansas history. And on October 29, 2002, the jury returned verdicts of guilty on 2 counts of capital murder for the deaths of Troughton and Luica and 1 count of first-degree murder for the death of Lisa Stassi. And Robinson was sentenced to death for the capital murder convictions and to life imprisonment without parole for the Stassi count, and in a subsequent plea agreement with Missouri prosecutors, He acknowledged responsibility for the deaths of 5 additional women in Missouri, receiving further life sentences without parole in exchange for Missouri's agreement not to seek a second death penalty proceeding. And the Kansas Supreme Court upheld his death sentence in a 415-page opinion issued in 2015 that rejected almost all of his appellate claims while acknowledging a number of trial errors whose cumulative effect the court found had not substantially prejudiced his right to a fair trial. And John Edward Robinson Sr. remains on death row today at the El Dorado Correctional Facility in Kansas at the age of 81. Having filed multiple appeals that have not altered the fundamental legal conclusion that a jury reached in 2002, while investigators have noted that the true number of his victims may exceed the 8 who have been identified, and that there are periods of his criminal career for which no full accounting has been achieved, leaving open questions that the families of several missing women have continued to pursue without resolution.